Well, the court didn't exactly disagree with it. They just said that they're not the ones to figure it out. It's not going to be a matter for judicial resolution under Section 3 of the 14th Amendment, but it's up to Congress to enforce it. I did agree with that interpretation just because the other parts of the 14th Amendment are self-executing. People can go to court and say that something violates equal protection, even if there's not a federal statute that allows them to do that. But in any event, the Supreme Court punted and said it's up to Congress to act. And so I am working with a number of my colleagues, including Debbie Wasserman Schultz and Eric Swalwell, to revive legislation that we had to set out a process by which we could determine that someone who committed insurrection is disqualified by Section 2 of the 14th Amendment. And the House of Representatives already impeached Donald Trump for participating in insurrection by inciting it. So the House has pronounced upon that, and there was also a 57-43 vote in the Senate. The question is whether Speaker Mike Johnson would allow us to bring this to the floor of the House. Well, I think that's just a reflection of the existing electoral system patchwork that we've got. There are some potential candidates who've been able to get on the ballot in some states and not other states. In some states, it's very difficult for an independent or a Green Party or a Libertarian to get on the ballot. In other states, it's much easier to get on. So that patchwork already exists. That's just a reflection of existing electoral federalism. But obviously, the Supreme Court did not want to step up to the plate and deal with the clear textualist meaning of Section 2 of the 14th Amendment, much less did they want to deal with the original purposes of Section 3 of the 14th Amendment, which was to keep out of federal office people who had already proven themselves disloyal and untrustworthy. Well, first, let me go to your original point about the Supreme Court kicking everything to Congress. I think it only does that when it doesn't like the ultimate inescapable implications of just enforcing the Constitution as written. That's what's happening in this case. But when you take like the Voting Rights Act, for example, in Shelby County versus Holder, the Supreme Court decided to take up the Voting Rights Act and then cut the heart out of it, dismantling the clearance mechanism which is in there. So I think that this court just didn't want to go anywhere near it and is saying Congress has to deal with it, knowing that the Congress is split because there's a very narrow Republican majority in the House and a narrow Democratic majority in the Senate. So we're going to fight for it, but it looks like this is a constitutional norm that the people of the United States are going to have to enforce at the ballot. Well, the vote to impeach Donald Trump for inciting an insurrection against the Constitution was 232 to 197. And we were joined by 10 Republicans at the time, including famously, of course, Liz Cheney and Adam Kinzinger. Most of those members are gone. A couple of them are still around, but it seems like Mike Johnson and leadership of the GOP are very clearly under the spell of Donald Trump and would probably do everything they could to keep this from going to the floor, even though it's just the mere enforcement of a clear constitutional command, as the Supreme Court itself pointed out. They're just saying, we're not the ones to do it. Congress has to be the one to do it.